We welcome you to the November 3rd, 2021 setting, 7th Court of Appeals. We had a Zoom argument earlier this morning, and it went well, and we're looking forward to an in-person argument now, too. It's a totally different feel, so thank you for coming and participating in it. We'll go on and call the docket. And since you're here, I will just assume you are ready to proceed, so I will not ask you that question. It's taken me a number of years to finally realize that's a dumb question. Well, you're here, you would be ready. So I'll dispense with that. And the case we have this morning is 07-20-00315-CV, the City of Amarillo, Texas, and Jared Miller in his official capacity as a city manager versus Nathan Sloan Nurek, and if I mispronounced that, I apologize, and somebody correct me, and Michael Brandon Stennett. And for the appellants, even though we have cross-appellants, Ms. Lynn, you're here, correct? Yes, you are.
Yeah, I am here.
There you go. And Mr. Bishop?
Backup, Your Honor.
Backup. Okay.
Judge, I also have with me Leslie Schmidt, who's the senior assistant city attorney at the city of Amarillo.
Very good. Are you going to be dividing argument, or will it just be you?
It will just be me.
Very good.
Easier for moral support than kick me if I get off.
I will leave the kicking up to her then, if need be. Why don't we do this? I don't think anybody asked for an additional time, but we had cross-appeal earlier this morning in the Zoom argument, and we gave each side 20 minutes for the main presentation, and then we gave each side a 5-minute rebuttal because there was a cross-appeal. So we'll go on and do that as well, too. How you want to structure your arguments, we'll leave to you. With that said, Ms. Lynn, you have the floor.
Good morning. Thank you for having us today. You may remember that about 4 or 5 years ago we were here in this court on this very same case. So we're glad to have an opportunity to come back. Do you want me to announce that you're going to give us 20 minutes and then 5 additional? Okay.
And I'm going to ask you a favor. It wasn't in your brief, even though the rules of appellate procedure require you to put one in there, but give me a summary of your argument.
Oh gosh, that'd probably take me 20 minutes, but I will try to give it to you as best I can. The summary of our argument is that most of the conclusions drawn by the trial court were accurate. The one that we object to, and one of the reasons we're here, is whether under the Civil Service Law of Texas, Chapter 143, whether employees of the separate fire marshals office are covered by Chapter 143 of the Civil Service Act, and all of the arguments flow from that. We had findings of fact and conclusions of law that are in the file, I'm certain, and they were numerous, and for the most part we agreed with what the judge concluded, but we had several that we disagreed with. Primarily, one conclusion he reached, that the fire marshal's office employees were covered by Chapter 143. That would be one of the main focus of our argument today.
You had, I apologize, you had originally briefed an issue on attorney's fees, but then in the reply you didn't address attorney's fees. Is that something you're still urging, or have you reconsidered that argument?
What we decided to do would be to leave that to the court based on our briefing, and so we did not continue to address it. And I knew that our time limit would be pretty small on our major issue, And we thought that the briefing on our side, anyway, with the attorney's fees would be sufficient for the court to make a judgment, if that works for the court.
And just one more preliminary matter.
Judge.
Your briefing fails to identify the standard of review. Is it the legal and factual sufficiency issue, or what exactly is the basis?
Well, it's the legal issues that we primarily have an issue with, but the legal issues are formed by some of the factual conclusions. As you may have noticed, there were lengthy findings of fact and conclusions of law, and we appealed several of those, but not all of them, because we were satisfied with all but a few of those, which I'll be mentioning in my brief. But it would be the legal sufficiency and as well some of the factual findings that we disagreed with, which are based on law.
Well, and I guess that's what Justice Parker was asking. So, for example, the question, the lower court erred in concluding that all FMO employees are employees of Amarillo Fire Department. Is that something we assess as a matter of law, or is that something that can be determined based upon the specific facts of a particular case?
I believe that's going to have to be a looking and a consideration of the law on that, because the elements of coverage, there's 4 elements of coverage that we'll be discussing, and so that's definitely an issue of law. But as I see it, there are certain facts that have to be in front of the court to be able to determine the issue of law. And I apologize in advance that I didn't get that into the brief. So what I'd like to do with my time is to pick up where we left off several years ago about the history, and not the entire history of civil service, but I want to start with the history of civil service where we pick up, and we're picking up in the early 2000s. And we have in Chapter 143 is where we have the civil service law. And there was originally the history of the law was in 2001. The legislature changed the definition slightly as to who was covered by the Civil Service Act. And in that particular amendment, the legislature decided to said that it requires the position, if it's going to be civil service, requires a substantial knowledge of firefighting. There were some issues back in the early 2000s about whether certain, not just here in Amarillo, but also primarily in Plano, Texas, about whether certain categories of employees here, the fire marshal's office employees, were actually, did they qualify, or do they have to come under civil service? And our argument is that they don't meet the requirements. And what we'd like to do is remind the court of what another amendment was passed in 2005 in an attempt to clarify what they had meant by the 2001 amendment. And so there's 4 major parts to that the court, in our opinion, needs to include. Number 1 is each person from the FMO, are they a member of the Amarillo Fire Department? The city's answer is no, and I'll be discussing that in a few minutes. Number 2, were the employees of the Amarillo Fire Marshal's office. I'm pointing to the fire marshal here in case, just to show you who he is. The second part is, were they appointed in substantial compliance with Chapter 143? And the answer is no. Number 3, and this is probably the most difficult of the 3, both for factual purposes, do the fire marshal office employees have a substantial knowledge of firefighting? And that leads off to a bigger issue, is what is firefighting? And that is the major legal issue that I believe, and Mr. Backup may agree on that, has to be decided by this court. The 4th item is also a legal issue. Do the fire marshal office employees meet the requirements for the certification as firefighters under another statute, which is the Government Code 419. And I'll tell you about the history of the law. It's the city's position that
You didn't answer that question. So is that an issue in the case?
Yes, that's an issue in the case also. And it's the city's position that the contents of 419, which Mr. Backup will be telling you is what their position is on that. Our position is that it does not, the definitions in 419 do not bring the fire marshal's office people into civil service. And I'll explain that in more detail. And it's very important to remember as I'm going through my argument that the legislature in 419-032, there is a laundry list, and I think that we attached that to our brief. There's a laundry list of functions that a person would perform to be covered by civil service. And the city's position on that is that the fire marshal's office employees do not meet those requirements. And on 419-032, what the other side, what the appellant, cross-appellant, are saying is that they choose a different part of 419. I need to explain when it was codified, they didn't specify, the legislature didn't specify 419 ... It was just 419. So after thorough review of 419, it was the city's conclusion that it was not talking about the same laundry list that's found in the civil service definition of firefighter, but instead it's looking at 419-032, which is also in the materials that we have submitted to you. And in 419-032, I will read to you just the definition about appointment of fire protection personnel. The fire department, so that would be Amarillo, may not appoint a person to the fire department unless the person has satisfactorily completed a preparatory program of training in fire protection. And it goes on in another section to say that fire protection personnel, this is subsection C, by the way, fire protection personnel must complete a commission-approved, and commission is the Texas Commission on Fire Protection, must complete a commission-approved training program, and these are the critical words, in fire suppression before being assigned to fire suppression duties. So this really revolves around what is fire suppression, and I will tell you what the definition the city believes this covers. And I think that Mr. Backup will tell you something else in their opinion. The facts are in agreement that none of the fire marshal office employees have completed a commission-approved training course in fire suppression. And fire suppression, it was referred to at the trial court as the red trucks. Firefighters who go out on fire trucks, and they also have emergency medical personnel. That is fire suppression. They're putting out fires, they're fighting fires, that type of thing. There's a lot of things that the fire marshal's office employees do, which are, as we'll discuss in our argument, have nothing to do with the fire suppression. None of the employees in the fire marshal's office have the certificate in fire suppression.
Do any of the duties of the fire marshal's office include certain aspects of fire suppression? Even though there are a lot of duties that, in your view, are not involved in fire suppression?
Yes, sir, there are. Let me just, it's a good place for me to tell you about what the fire marshal office does. The fire marshal's office in Amarillo is critical, for example, for the building industry here, which I understand is booming, new business, housing developments. Let's say that one of you wants to go and do a new building. You have to go to the fire marshal's office with your plans, and they have to, plans checkers and plans reviewers have to look at those plans to make sure that they conform to all fire codes, not only Amarillo Fire Code, but there's a national fire code. And so that's one example.
For what purpose do they assure that they conform to fire codes?
Because the fire codes are written, and the people that do that work, and that's kind of your first level of work, they are all trained in that. They have instruction in that, and they're certified into plans checking.
Does that involve fire avoidance and minimization of fire?
Not at that point. It wouldn't. It would. Let me give you an example.
Is that why they understand their codes they have to be complied with? those codes are they in existence for the purpose of minimizing fires and avoiding fires?
Well, there would be two parts. You're right, Your Honor, you're right on that, Judge. The other thing is to make sure that the building is built properly so that it has the right kind of, it's not plumbing, but they have the right kind of system installed for fire prevention as well. Yes. But they don't have to know about putting out a fire. That's suppression. The hose, people that drag the hose and that type, that's suppression. But it doesn't take any knowledge of that, and I should tell you...
Why wouldn't a sprinkler system that hasn't been activated yet be considered part of fire suppression?
It wouldn't be.
Why not?
Because it's not suppressing a fire. Suppressing a...
But its purpose is to suppress a fire because it will not become operative until there is a fire.
Well, that's probably correct, and I'm sure it is correct, Your Honor. But the matter of the fact is that the people who are doing the plans checking are not there to put out the fire. It is the actions, the way we've always looked at this, it's the actions that the employee takes, not necessarily the result. And the result here, fortunately in Amarillo, for many, many years, is that these things are working well, so that there's fewer, across the nation, there are fewer fires because there's better fire codes, there's better enforcement of fire codes, and that is all done by the Fire Marshal's Department. And they do not have any experience or training in structural firefighting.
Let me ask you
Yes, sir.
a question. Your 4 elements that you were discussing, member of the fire department, all the way down to to meet the requirements for certification. What is the source of those 4 elements?
The source of the 4 elements is in the statute itself.
419.032?
No, 143.
Okay.
Chapter 143.003.
003. Here's why I'm asking, because when you're talking about 419.032,
Yes.
that doesn't say you cannot become a member of a fire department unless you do these things. 419.032 says the fire department may not appoint someone. To me, that seems like the definition is more of a restriction on what the city can do and not on whether the person meets the requirements or not.
Well, I'm not certain that that's how I would interpret it. And I need to draw your attention, and I believe it's in the briefing, the definition under 143.003, and I think that'll clear up the questions that are being asked. It defines firefighter as a member of a fire department appointed in substantial compliance with Chapter 143, or who is entitled to Civil Service Statute sections, and these were grandfathering from way back, so I won't talk about them. Then there's a list of about 10 things that are seen as fire suppression duties. For example, that includes a person who performs fire prevention.
And I think that's what the chief was asking about.
Yes.
Is that under 143.003,
Right.
4A, there's a laundry list of those employees who perform certain tasks, and it wasn't simply limited to fire suppression, but there's a disjunctive or that it also covers fire prevention, fire training, fire safety education.
Yes. Now, there's another part of this that I haven't gotten to mention that I think also clears this up. And in 2005, when the statute was amended, they added some, and it was not just substantial knowledge of firefighting, who's met the requirements for certification, but also there was an amendment, and this is written in our briefing, a floor amendment in the under Chapter 419, and they added in the 419, but the part they added in our opinion, was not the part that the cross-appellants believe was added in. The cross-appellants believe that it added in the laundry list, and I think that that's not right as a matter of law, because the courts do not particularly look well on a situation where the same words are referred to in another statute. So to me and to the city, what that means is that adding on part is not the definition but it's the other part of the statute, and unfortunately, the legislature didn't define what it was, but that's what flows out of 032, where you cannot put a person in a fire department unless they have satisfactorily completed a prep program of training in fire protection, and that's learning how to be a hose person and a ladder person. That's the fire protection that the legislature, and they added that. And so...
Well, you're mentioning, let's talk about that 2005 amendment.
Yes, sir, ma'am.
You made a point in your briefing about that it was necessary for the association to accrete, that the city accrete the fire marshal's office into the fire department. And there was provision set up and a grandfathering provision back in 2005 to accomplish much of what this lawsuit has encompassed up to this point. You seem to put the responsibility on the association for that, but yet we understand that they don't have the ability to, or the authority to pass an ordinance. That's in the city's realm. So could you explain why?
Yes, I can. Number one, I noticed in studying this again for the many times, that and there's no dispute about this, the Fire Association, which is a legitimate association permitted under state law for, they're not called unions, but association, that the association was aware of this amendment, and the association never brought it to request that of any council member.
Well, but isn't it the council's members' duties to pass ordinances?
Well,
are they not aware of this newly passed legislation?
That is not in the record, and it was never asked by the other side. My presumption is that it was never asked for, and that's based on what's in the record was that we had testimony at trial of the then president of the association, and he was aware of the amendment because I believe it was the unions in the Firefighters Association of Texas that was one of the chief sponsors of it. And he went around and talked to many people in the fire department. Is anyone interested in these jobs? All the different categories. And he testified, I think credibly, that no one was interested. Nobody wanted to go over there for whatever reasons. Nobody wanted to be a FMO. So I believe his exact words, so we dropped it.
So that relieves the city's responsibility from complying with state law?
Well, I don't think that was a responsibility to do anything at the time. And I'll explain why. There were two different cities, and if you looked in your law clerk may have looked at the statute, and you'll see there's two different versions. There was what I called the Amarillo version, and there was another called the Plano version. And the Plano version is really more important in many ways than the Amarillo version, because there it's a much larger fire department. The city had hired a man who had been hired into the fire department, and he was hired to help them start up their medical service. This is in the early 2000s. And he was put in at a high level, like assistant director level, and the union just jumped all over that in Plano. So they had the Plano version, which basically grandfathered that gentleman so that he could continue to work. Otherwise, they were going to have to fire him.
And then the Amarillo version grandfathered members in also.
Well, it enabled them. It wasn't automatically that it happened.
It would take an ordinance.
It would take an ordinance, but it would also take interest on the part of the firefighters. Because here's what would happen. If they had passed that ordinance, and this is all assumption on my part, if they had passed an ordinance that we're accreting these jobs in, but if in our briefing you will see that there was a problem with that for Amarillo. Number one, in fact right now, all but one personnel are over the age of 35, and to be in the fire department under civil service, you cannot be over 35. So it would cause all of those people, except for one, on the basis of their age, to lose their jobs right now. And there were many over 35 at that time, which was 15 years ago. And that would be a detriment, because no one in the fire department had any of these certifications at that time. It takes a whole year to be certified as a law enforcement, which several of the employees are, because they have to be able to make arrests and do arsons. The second reason was that there's two pension plans. We have a citywide pension plan, but a long time ago, the state of Texas established a different pension plan for firefighters in various cities. It's kind of an agglomerated type of pension plan. Number one, you can't be over 35 to get in the pension plan. And number two, if you were over here and you were in it's called the TMRS pension plan, which is all the rest of the city employees, if you weren't vested, which is 5 years, you would lose all the city's contributions. So it was economic and a practical reason that the city didn't take action at that time to say, okay, you might not like this, but we're pushing you all over into Chapter 143.
Yeah, your time has expired. Let me ask the fellow judges here if they have any questions, any additional questions.
Did the trial court's summary judgment resolve Stennett's request for injunctive relief?
No, he denied that.
So was that as a part of the summary judgment?
No, that was at the trial, after the trial court. I have to
included
look
in
over.
the judgment?
I believe so. I can check that. Since my time is up, I'll check that when I'm sitting over here.
Yes, that'd be great.
All right, thank you.
I don't have any at this time, yeah.
Thank you. Thanks for your attention.
Yes, ma'am.
May it please the court. I'm going to attempt to split my time between the coverage issue that Ms. Lynn spent her time on and the defensive issues that the trial court ruled for the city on. There's a lot here, so I'll see how far I get. Obviously, my first priority is answering the court's question.
What happened to Nurick?
Mr. Nurick didn't appeal. He's not represented as an appellee on appeal.
So it wasn't a non-suit, and if this case is reversed and sent back to the trial court, is he a part of that?
Well, I guess it depends on how it's sent back to the trial court.
But he didn't file, he's just not participating in the appeal?
Correct. I'm not representing him on appeal. He hasn't filed anything in the appeal. And so, starting with this issue of whether the FMO positions are covered by the Civil Service Act, I mostly agree with Ms. Lynn on what the elements are. You know, to be covered, the person has to be an employee of the fire department, whose position requires substantial knowledge of firefighting, and who's certified by the Commission on Fire Protection. And then, as the court's seen, the statute gives a non-exhaustive list of the type of job duties that make one a firefighter, including the fire prevention, fire safety education, and fire arson investigation duties that are performed by Amarillo FMO employees. And so on the first element, is the FMO within the fire department? Ms. Lynn didn't really argue that, and so I'll try to breeze through, but the evidence that we presented that supported the trial court's ruling on that were testimony by the fire chief and the former fire marshal that the FMO is in the fire department, the city's sworn discovery responses saying that the FMO is in the fire department, many organizational charts and budgets all showing the FMO within the fire department, the physical housing of the FMO within the fire department, a strategic plan for the fire department that was published to the public, which includes goals for the FMO. And so against all that evidence, the only thing the city points to is a few lines of testimony from the fire chief where he contradicted himself in the other evidence and played a little word game where he said that the fire department is actually a fire division and the FMO is a department within the division. And, you know, Justice Parker asked, what's the standard of review? I think this is plainly a factual and legal sufficiency point for the city. I don't think they've come anywhere close to showing that there was no evidence or factually insufficient evidence to show the FMO is within the fire department.
I think what Ms. Lynn, though, is arguing is to say, under 143.003, firefighter means a member of a fire department, which includes all of these other things, but you can't be a member of a fire department unless you also meet the requirements under 419.032.
And I think that is part of her argument, and that's a statutory interpretation issue, because the facts are clear. All these FMO employees are certified by the Commission on Fire Protection under Chapter 419. You know, Ms. Lynn says, well, the reference in the Civil Service Act to Chapter 419 is actually just a reference to this one section and not to the entire chapter. You know, of course, that's not how statutory interpretation works. Chapter means chapter. And so if we look at Chapter 419, that's the only chapter for the Commission on Fire Protection. And they set out in the beginning at Section 419.021, there's a definition of fire protection personnel. And that definition is very similar to the Civil Service Act's definition of firefighter. And it's fire protection personnel are fire department employees who perform specific duties that include extinguishing fires, like the city wants the court to focus on, but also includes inspections, fire and arson investigations, fire education, and anything else related to fire prevention, which is what the FMO employees
It's almost the same list that's included under 143.
It's very similar.
And the question I was going to ask is, let's take an example then where we got somebody who would otherwise fall under 143, but they have not had training in fire suppression that's been approved by the commission. Does that mean that that employee would still qualify as a firefighter in your interpretation, even though the city might be outside of compliance under 419?
And so I think there's an issue here on fire suppression versus fire protection. And so Chapter 419 says that to be fire protection personnel, you have to have gone through training in fire protection. The fire suppression training is only required to be appointed to fire suppression duties. But there are fire protection duties that do not involve fire suppression. And the way the Commission's made that clear is in its administrative regulations. And this is at 37 Texas Administrative Code, Section 421.3. And in that section, the Commission breaks down fire protection personnel into 18 different disciplines. And that includes the structure fire protection personnel that Ms. Lynn calls the red trucks. It also includes fire inspection personnel and fire investigation personnel, like the FMO employees of the Amarillo Fire Department.
So your argument is under 419.032C, that covers the category of people known as fire protection personnel, but you don't necessarily have to be fire protection personnel to be employed by the fire department, right?
You do have to be fire protection personnel, but you don't have to be fire suppression personnel. And so the 18 categories of fire protection personnel, almost all of them do require fire suppression training, but the ones that don't are the fire inspection and fire investigation disciplines that the FMO employees work under. And so the final statutory element is the substantial knowledge of firefighting. Now, this is just a legal issue with no factual disputes. We all agree that the FMO employees have substantial knowledge of fire prevention. We're not arguing that they have substantial knowledge of fire suppression. And so I think there were some questions from Justice Quinn about the sprinklers. Are those fire suppression? I wouldn't argue that. I think if the court decides that firefighting means fire suppression, we lose. But I don't think there's any reason for the court to conclude that. You know, there's a 2003 opinion by then Attorney General Greg Abbott that makes our lives a lot easier on this element. And the opinion says, if a position performs any of the duties in the 10-duty laundry list in the statutory definition of firefighter, then that position requires substantial knowledge of firefighting as a matter of law. And when the legislature enacted the current version of the statute in 2005, they explicitly said their intent was to codify that 2003 AG opinion. And of course, the FMO employees do perform duties on the laundry list: fire safety education, fire prevention, and arson investigation. And so their positions require substantial knowledge of firefighting as a matter of law. So I think there was support for the trial court's ruling on all three elements of the statutory definition of firefighter.
What is substantial knowledge? Does that matter? Is that in debate?
I don't think that is in debate. You know, if Firefighting includes fire prevention. I think the record is replete with references that the FMO employees are trained on, educated on, experienced in fire prevention. That's what they do day in and day out. I don't think there's any dispute they have substantial knowledge of fire prevention. I want to turn and talk about the next big picture issue, whether the city met its burden on the affirmative defense of good faith that comes out of the case law.
Okay, so that, the good faith, the city contends, that, I guess, initially that they're not bound by good faith requirement, but that's coming out of case law, and that has to do with civilization of positions?
Right. So the cases have created a safe harbor for cities that even if they're illegally using non-classified employees to perform duties that the statute requires to be performed by classified employees, they have a defense if they can show that was done in good faith, which in this context means using unclassified personnel would be more satisfactory to the public, it does something more than save money, and that it's done to affect an economy in operations or a betterment in municipal services. And the city didn't put on evidence to try to meet that standard. Instead, the city invented a new standard and tried to show they had evidence to meet that. And what the city tried to show was there was a good faith reason to employ the particular people that held the FMO jobs at the time of trial, rather than using the particular people who held classified positions at the time of trial to work in the FMO positions. And even after twisting the standard so much, the city still failed to meet it. You know, the primary argument was about certifications. And the city's briefing says none of the classified firefighters have the certifications to do the FMO jobs. But what the trial evidence actually showed is that the fire chief didn't even bother to check if any classified firefighters had those certifications. And we had the district chief over training in the Amarillo Fire Department say, we do have classified firefighters that have those certifications. We introduced a printout from the Commission on Fire Protection of one of the classified firefighters showing he has the certifications. And the district chief over training also testified, Amarillo Fire Department has the capability to offer those training courses in-house to get more classified firefighters those certifications. And the city's only other argument on good faith is none of the classified firefighters want to work in the FMO positions. But that's just something Ms. Lynn has said. There was no trial evidence on that. In fact, the only trial evidence on that point at all was the testimony of 4 classified firefighters who all said they would work those jobs. And so our argument is there's legally and factually insufficient evidence to support the trial court's finding that the city proved this affirmative defense of good faith, and so we're asking for that portion of the judgment to be reversed.
Okay, so you're asking for rendition of judgment, I guess, first. If we conclude that the fire marshal's office should be classified as civil service and the association is not a real party in interest, as they were not an actual party, what's the judgment that we should render?
I think we're asking for rendition of judgment on the merits for the retroactive promotion for Mr. Stennett that we pleaded for the declaratory and injunctive relief on the requirement of classification of the FMO positions.
Okay, was that, and I tried to ask that question earlier to Ms. Lynn, and I don't think I asked it correctly, but did the trial court's summary judgment dispose of your request for injunctive relief seeking to establish the civil service classification?
I didn't understand the summary judgment to dispose of that issue. I was a little caught off guard by your question on that to Ms. Lynn as well. That's not something I looked at, the summary judgment record in preparing for this. That's not how I understood the order.
Well, okay, you didn't appeal the summary judgment that was granted in the, or the partial summary judgment granted in the city's favor, which I guess, and you also didn't appeal any ultra vires action. So of the things you pled for declarations, which ones of those are still viable?
Well, I believe, so the summary judgment order, as Your Honor said, was partial and so not an appealable order. Once we...
Well, it became appealable once it became incorporated into the final judgment.
That's right. And so to the...
But you've not challenged that, unless I'm missing something.
I don't think there are any rulings that were made on summary judgment that we've appealed. I think what we've appealed were the...
rulings in summary judgment?
I believe the rulings on summary judgment were mainly releasing several of the defendant parties, and my understanding was that some parties were carved out, but that all the claims went forward against the parties that remained.
Let me ask it this way. Do you, in your live pleading, you wanted a declaration that certain defendants, Miller, Nelson, Hayes, Powell, Sauer, and Smith, failed to establish civil service classifications for firefighter positions by ordinance. Is that still viable, or was that taken? Did the summary judgment cover that declaration?
I mean, to the extent the summary judgment dismissed those parties, I think it does cover that
Okay,
declaration.
I think I would agree. That there was a declaration that Hurt, Jennings, and Walker's failure to provide for classification of firefighter positions as civil service positions. That would also be, that was number two. That would also be taken into account by the summary judgment.
I agree with that, Your Honor.
Okay. A declaration that defendants' illegal conduct led to a failure to promote plaintiffs to positions for which they had the highest grades on the applicable promotional eligibility list.
I think that was not addressed by the summary judgment. That's something that's still live.
And then issue injunctive relief, which was denied, requiring defendants Miller, Nelson, Hayes, Powell, and Sauer, and Smith to establish civil service classifications for firefighter positions in the FMO by ordinance.
And I think that's partially still alive to the extent we had good defendants after that.
Okay. And those would be, okay. And then issue injunctive relief requiring defendants Hurt, Jennings, and Walker to provide for the classification of the firefighter positions in the FMO as civil service positions.
And I agree with Your Honor. We didn't have those defendants after summary judgment.
Okay. And then issue injunctive relief, I guess now it's just with regard to Stennett.
Right.
Right? About the retroactive promotion. And then your issue as to attorney's fees.
Yes, sir.
So there's no injunctive relief that's still viable?
I believe there's injunctive relief on retroactive promotion
Yeah, okay, okay.
and on the classification against our live individual or official capacity defendant,
And who's that?
the city manager.
On the illegal conduct portion for the retroactive promotion, is that something we can actually render, or do we have to send that back? If we were to reverse, is that something we'd have to send back to the trial court to make that determination?
Send back because of the dates involved, or?
No, I'm saying if we have to reverse, do we say that's illegal conduct as a matter of law that would allow for a rendition? Or is that something we would have to send back for the trial court to make a determination based on the other facts?
Well, I think the trial court made the determination that the FMO positions are covered. I think the trial court also made the determination that Mr. Stennett was personally harmed. We have fact findings that he was number one on the list when there was an FMO vacancy in the FMO position that's closest to the classified rank of captain, that he wasn't promoted as a result of that vacancy, and that he would have been promoted if the FMO positions were classified. I don't think the city challenged any of that on appeal.
So your argument is that if we agree with you on that issue, then the trial court would have no discretion but to retroactively promote?
I think that's right. That's what the cases say. The remedy is retroactive promotion for a failure to promote in accordance with the statute. And so if the court believes the trial court got it right on statutory coverage and reverses the trial court on the defensive issues, then yes, I don't see where there is discretion to deny the retroactive promotion. And I'll start talking about these other defensive issues in my last minute and a half. And this issue is whether any action or inaction by the employee association that Mr. Stennett is a member of establishes a defense for the city. And the trial court found latches, limitations, and estoppel based on the association's conduct only barred Mr. Stennett's recovery. And there's two main sets of reasons that the court should reject the district court's.
Was the association representing Mr. Stennett, or was Mr. Stennett representing Mr. Stennett? You understand the difference I'm saying?
No.
Who sued?
Mr. Stennett sued.
Association sued?
No.
Mr. Stennett urging any rights on behalf of the association?
No.
The association intervene?
No.
The association take up a formal position somehow in the lawsuit urging any rights on behalf of Mr. Stennett?
I don't believe the association didn't take an official position. The president did sign an affidavit on summary judgment.
So he was a witness?
Correct, and he was a witness at trial.
And the position they took, though, was not a position in court. It was a public show of support, not an appearance in court, right?
That's correct, Your Honor.
Is the association bound by the trial court's determination that the FMO is part of the fire department?
That's a good question that I hadn't thought of.
I guess it does that. The association has standing when one of its members is not promoted, to urge it on behalf of the member. And that's related to Judge Parker's question.
Right. That's a fight that Ms. Lynn and I have had across the state, and I always say the association does, and she always says the association doesn't.
What does the court say?
It's gone both ways. I can't think of a reported appellate decision that analyzes that issue, though, Your Honor.
You have an unreported appellate decision that analyzes?
I'm only thinking of trial court decisions.
If let's take Ms. Lynn's position to be the correct one for purposes of this argument. If Ms. Lynn's argument is correct and the association doesn't have standing, then how can the association be a party in this case, standing by themselves?
Yeah, I don't understand that contradiction either, Your Honor. I think the city's abandoned the lack of standing argument at this point.
But even for there to be standing, you still have to have the individual against which standing is being urged a party.
I think you would.
They're a party.
They're not. I'll sit down unless the court has more questions. Thank you.
I have 5 minutes.
5 minutes, and as you've learned throughout your legal experience, when you get up in front of the court, the time changes. It goes a lot faster.
Yes, and we're not going on daylight savings time till next weekend, I believe. I wanted to try to address a couple of things that the court brought out in the questioning of Mr. Backup. There is plenty of case law that shows that an association, which you have here, does represent its employees. The association's not a party to the lawsuit. They're not on the lawsuit, but the fact of the matter is that the evidence, and we've had a lot of it in our brief, the evidence was that Mr. Havlik, who's the current president, was actually the association was actually the party, but not in name, because Mr. Havlik is...
The association. In a nutshell, does this lawsuit involve the failure to promote?
The lawsuit, in our view, is not the failure to promote. It's whether the fire marshal position...
Mr. Stennett urge, what's he complaining about?
He wanted, his exact words is, "I don't want the job, I just want the
What did
money."
he ask in his original complaint, or amended complaint, his live pleading?
He wanted to be promoted.
He wanted to be
Right.
promoted.
But
Is anywhere in the live pleading of a plaintiff urging that the association wanted to be promoted?
no, what they want is to get all the jobs under civil
I
service.
understand.
They don't care.
I want to grow hair too.
Right, I do
And
too.
I'm a party to this lawsuit.
And I want you to grow hair, which doesn't make me a real party in interest if you were to sue.
But I appreciate your sentiment. Okay, that's my question.
Yes,
The association was not a named party.
that's correct.
Even though the association may have supported Mr. Stenett's position, and the association may want, the ultimate goal may be to, in effect, combine the fire marshal's office with the fire department, or have them one in the same department.
That's correct, but the trial court, after listening to 3 days of testimony, and that was the week we had the ice storm here, that the trial court found, as you know, because obviously you all have studied this, our material, that the association was the real party in interest, and
What
that's...
does that mean?
That means that the positions, that they are the real party in interest, means that they are not only supporting him, but they're there for themselves. And I'm going to put it the way I would, and I hope that his legs won't kick me. I'm pretty far over here. That the association wants a bigger pie. He wants raise, was what he said he wanted. The association wants a bigger pie. They want more people that will join their association, that will pay dues, and it gives them some status. Now, the problem that the city has, which I've already, and so that's what that whole real party in interest was. And that was found by the court because during the testimony, during the trial, Mr.
But my question is, obviously, the association wants a bigger pie.
Right.
But what's it matter when the lawsuit is between Mr. Stennett and the city?
Well, because when that happens, exactly what we're hearing about and what you're asking questions happens. But this was really a lawsuit that should have been brought by the association.
Well, you
And-
objected that they didn't have standing.
Well,
How could the association have brought this lawsuit?
they could have, because there's a decision. I know that all 3 of you, I think, are from Lubbock. The Lubbock Professional Firefighters Association filed a lawsuit on behalf of their membership, not on the same topic, but they were found to have standing in that situation to go in, and I believe they sought some type of declaratory and maybe injunctive relief on that. There's a few years back, and I can get you the citation.
Oh,
on
no,
it.
we've got the site.
I think the question is, it sounds like the city of Amarillo is taking a convenient two-step on who can participate in the case. On the one hand, they're saying the association doesn't have standing and can't be the ones to bring the suit, but now on appeal, they're saying the association should have been the one to bring the suit, not the individuals. And that's what we're trying to figure out the
and
inconsistency on.
I can understand that because a lot of these facts didn't come out until the trial itself. For example, until we
Did you
got-
file a special exception or a verified pleading saying that Mr. Stennett in his individual capacity was not the right party capacity to bring suit?
Well, we didn't do exactly what you said, but we made the point in our proposed findings of fact and conclusions of law that, in fact, it was the association that should have been, because Mr. Stennett's testimony at trial was that he didn't want to raise.
If in order to challenge his capacity to bring suit, aren't you required to file a verified pleading?
Well, he could have filed suit. It could have been the Stennett and Nurick, and by the way, Nurick quit the fire department, so that's what happened to him. And I'm not any privy to the conversation, but so you have Stennett, but the real party in interest was, because Stennett was what we called, I think you saw in our briefing, we called him and Nurick the straw man. They thought they had to have a person, and
He's the one that applied for the job.
Neither one of them applied.
He's the one that's complaining about not being promoted.
They both were at the beginning, but Nurik's really out here.
Our questions have taken you past the 5 minutes we've allotted. We can give you about 2 minutes to sum up.
Okay,
How's that?
thank you. I would like to spend about a minute on the other issues here that the trial court even ruled in favor of the city, not just including the real party and interest, but the various estoppels, because this had taken a long time. That amendment was made in 2005, and there were other remedies the association could have taken, and we mentioned this in our briefing, which included meet and confer, which gave them more status, and that also passed in 2005.
And I'm not trying to pick on you, I'm just asking a question. That obviously is what the association could have done. Are you taking the position that because the association did not do that, that it also bound Mr. Stennett?
Yes, sir, because he's a member of the association, and we were never provided a copy of bylaws, because those are kind of held close by, and they're not available usually to city lawyers like I am.
But the injury to Stennett did not occur until 2015 or until 2016, when the position was filled by someone else.
Well, and exactly that's the point, because they sat on their rights from 2000.
Well, Stennett didn't sit on his rights.
But his association sat on its rights for that period of time, and he was eligible. They had 10 years.
Are you suggesting the association was duty-bound?
Yes.
Urge that
Yes.
on behalf of him?
Yes, I am.
Back in 2005, back in 2005, urge on behalf of Mr. Stennett
Well, anyone.
that he should receive a certain rank in 2015?
No, I'm not. I'm saying there was 10 years, and the trial court found this. There was 10 years that no action was taken by the association, which is how he came to the latches and some of the other equitable remedies that he had, because the city, not seeing any action for 10 years until 2015, when Stennett comes along and wants a promotion, and he didn't actually apply to take the test that he would have had to take to have a city civil service. So all of that time went by, and that's the reason that we have all the equitable remedies and equitable.
And just so we're clear on, I just want to make sure I understand this, because I haven't looked at this part of the record. There's nothing in the record to say there's any type of collective bargaining agreement or anything like that saying that Stennett can only act through the association, right?
You're correct on that. There's no collective bargaining that requires an election by the people. The meet and confer come into existence either through an election or the city council could approve of it. The city council did not approve of it. Then they did have it, and there's evidence in the record that actually they were engaging, because you can. It's kind of complex, but you can.
So I'm going to have to cut you off now. That extra 2 minutes has expired, but let me ask if any of the judges have any additional questions.
I don't have any.
Thank you so much.
Thank you. That's one of the interesting things about oral argument up here in the Court of Appeals, and both of you have done it before. You come in here with a game plan, but often the attorneys do not factor in the right of the judges to ask questions and remove you from that game plan. You know, it's kind of like what the ex-boxer, he said, everybody has a plan when you come in until you get hit the first time.
I would say that without taking it to court, that I felt like I was on the Supreme Court of the United States. Where I've never been, so thank you.
I'm not sure, well, I won't say anything. Whenever.
And I appreciate the active panel, and obviously we need to get y'all's questions answered. I guess my plan for this last 5 minutes is to talk a little bit more about latches, estoppel, and limitations. I hear that the court is on top of the real party and interest and imputing the association's conduct to Mr. Stennett. I wanted to talk about some of the...
Can I just ask you one question along those lines? Is Mr. Stennett required to be a member of the association, or is that a voluntary association?
He's not. It's a voluntary association. We're Texas Right to Work, and Janus, everywhere's right to work for public employees
We're
now.
not dealing with a labor union or anything like that in this case.
I mean, Ms. Lynn might say the association is a labor union, but it's a voluntary membership employee association. And so, another problem with laches and estoppel is that both of those theories require a finding that the city changed its position because the association or Mr. Stennett delayed in some way or concealed some fact. And there just wasn't any record evidence of that. The best I can tell, the city and the trial court's theory is...
Latches is more of a delay. Estoppel's the one with concealment, correct?
That's correct, Your Honor. Latches is delay, estoppel is concealment. And I think the theory is the city was planning to use the 2005 Civil Service Amendment and grandfather in these FMO employees, but then something that the association didn't do or didn't say caused the city to change its position. You know, that's the only way the latches and estoppel findings make sense.
Do we know who was behind the 2005 amendment? I don't know that that's in the record, just out of curiosity.
I believe there was some deposition testimony that there was a legislator from Amarillo that spearheaded that. You know, the city didn't put on a shred of record evidence. There's no piece of paper, there's no line of testimony that said they ever even considered bringing these FMO employees under the Civil Service Act. And so the idea that they changed position, at first they were going to grandfather and then they weren't, is wholly unsupported by the record. And so separate and apart from any problems with real party and interest and imputing the association's conduct, just factually the elements aren't met for latches and equitable estoppel. And limitations is probably the ruling I understand the least. You know, Mr. Stennett sued over promotional vacancies that came open in November and December of 2015. It's undisputed the limitations period is 4 years. He filed suit well within the 4 years. You know, in the city's brief, all they say is, well, you know, Mr. Stennett's not even really a party, the association's the real party, so don't look at when Mr. Stennett's claim accrued. But of course, you know, Mr. Stennett's claim is the only one at issue in the appeal, and so I think we essentially have a concession from the city on the limitations ruling, and that should be reversed. So I think, you know, to sum up, we're asking the court to affirm the trial court's ruling that the FMO positions are covered by the Civil Service Act, to reverse the ruling that the city met its burden to show good faith as based on factually and legally insufficient evidence because we had classified firefighters who were certified to do the jobs and that could do the jobs and that wanted to do the jobs. And then finally, to reverse the rulings on the three defenses that depend on the association's action or inaction and this change in position by the city that's just not supported by the record.
You seek a declaration that the city has failed to classify FMO positions as civil service positions. That is relief that would affect only Stennett and nobody else. Is that right?
Well, I think that relief would bind the city of Amarillo as a party to the litigation more generally than with respect to Mr. Stennett if the finding is the positions are required to be classified, and that's the declaration of the court. I mean, in this case, it only applies to Mr. Stennett.
I'm not sure exactly what the court declared. The judgment doesn't say. I mean, the judgment doesn't make it clear, does it?
Well,
as to what was declared?
I don't think the court declared anything in our favor because the court found that despite winning on the statutory issue, any relief was barred by these defensive issues. So there was no declaration on on the requirement of classification by the trial court.
But you may have a scope limitation that's the opposite of the one we were just dealing with on imputing conduct to the association, that if you can only get relief, you can only get relief on behalf of Mr. Stennett. You can't get relief generally as to anyone else.
I think that's right.
I mean, it would certainly put the city on notice, but in terms of declaring, so yeah, as I'm looking at the judgment, it didn't really declare anything.
I agree with that.
or enjoin anybody.
If you...
So it was a declaratory judgment action, right?
Right, and despite being on the appellee side, we lost. You know, we didn't get any relief. And so, yeah, there were no injunctions or declarations.
Well, okay, so, but the provision, I guess the relief, part of the relief, kind of, would be, paragraph 2 of the judgment, the provision of Texas Local Government Code 143.003 is applicable to the employees of the Amarillo Fire Marshal's office. Is that relief?
It kind of sounds like relief, and then later on the court said all the relief is barred because of these defensive issues. I think ultimately, reading the judgment as a whole, that's not relief.
Okay, yeah, so there's really, okay, so yeah, as I'm looking at it, so there were no declarations made, and there were no injunctions given.
That's my position, Your Honor.
Okay, all right.
Why couldn't there be a declaration made? But as far as an affirmative defense, you're not entitled to relief despite the declaration. Here's the law, I'm interpreting the law, here's the law. But under my interpretation of the law, you got an affirmative defense, which basically says it doesn't matter if something else bars you from recovery. It doesn't matter what that, the basis of your claim, something else bars you. Why couldn't the court be saying that?
Well, yeah, I think the court did.
Okay, so there is a declaration, but...
Well, no, it's not a declaration. It just says plaintiff's recovery and requested relief are barred by the application of laches, limitation, and estoppel.
I think the court has suggested a plausible reading. I think the court was more clear than the trial court was in its order. But yeah, that's one way to read the judgment.
Well, we're not indicating how we're going to decide one way or the other. I mean, our questions up here, as you know, is all devil's advocate to begin with. But yes, we're just trying to wade through everything before us. Any other questions? Counsel, thank you very much.
Thank you.
Case is submitted, and you are excused to go. We do thank you for coming up and presenting argument and your thorough briefing. And you will be hearing from us in due course of time. Thank you. We'll be in recess for the moment.